Deferred, deferred, deferred is the word. Yes, deferred, deferred, deferred is the word. Why is this lawyer singing? Well, because this is a video about deferred sentences, deferred dispositions. The term deferred as it applies in Washington state criminal law and in infractions, and that deferred word can be confusing. So if you're interested in the law, if you've heard something about something being deferred in the case of yours, stay tuned because this is the video for you. My name is Attorney Lance Fryrear, and I've been defending people charged with crimes for more than 20 years. And I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people will get the help they need. So what is it about that word deferred? In my 20 years of practice, so many people come up to us and say, hey, what about a deferred? And I always have to say, well, what do you mean? There's about 4 main types of situations in Washington criminal law and in civil infractions where the term deferred comes up. So in this video, I'm going to try to cover all 4 and what they mean. So the first one I think that comes up the most is something called a deferred sentence. A deferred sentence applies when somebody is convicted of a crime, usually if they plead guilty. The judge has the option to suspend part of the sentence or to defer the sentence. And a suspended sentence means it stays on your record. Once you're up with probation, it just stays a conviction. Well, if you get granted a deferred sentence, and this is on a non-felony charge, then at the end of the probationary period, usually 2 years, at the end of the probationary period, the court can undo the guilty finding and enter a dismissal in your case. And that means your case is dismissed. Now, there's some complicated factors. You still might want to vacate the record of conviction later, even though the court has dismissed your case. But a deferred sentence is much better than a suspended sentence because you can say, hey, my case was dismissed. So that's number 1 is a deferred sentence. I think the most next common type of deferred is called deferred prosecution. Deferred prosecution is a statute here in Washington state, and we're going to link to it in the description. But basically it says for most non-felonies, misdemeanors, and gross misdemeanors, once in a lifetime, you can petition the court to put you in a deferred prosecution program. And a deferred prosecution program is something where you have to go to an evaluator, either an alcohol and drug evaluator or a mental health evaluator, and it has to be found that you either suffer from an alcohol or drug problem or a mental health problem that basically caused the crime that you're being prosecuted for. And so this law says that once in a lifetime, if you get the right type of evaluation, you can petition the court to enter a deferred prosecution. So what that means is while you admit that you're guilty of the offense, the court doesn't find you guilty. They enter you into this alternative program. And the most common situation would be for a DUI. We have a video, we'll link to it here, about deferred prosecution. But in deferred prosecution, you go in an alcohol treatment place. Usually they're going to recommend a 2-year treatment program. Then if you successfully complete the 2-year treatment program and stay out of trouble for 5 years, then the court can dismiss your case. No conviction, no, for the most part, no suspension, of course, no jail time. And it varies. There can be a license suspension there too, and that's covered in the other video. But deferred prosecution is not a deferred sentence. Deferred sentence, you're found guilty, and later that gets turned into a not guilty if you do what you're supposed to do. And that can apply for any type of sentence. You don't have to do special things. Deferred prosecution, you have to get an evaluation that says you're qualified, you have a big enough problem that you need to enter into a very serious treatment program, and then you're not convicted. It's sort of held over your head for typically a period of 5 years. And if you successfully complete the deferred prosecution, the case is dismissed. If you mess it up and the deferred prosecution is revoked, then that's pretty bad. You're going to get convicted of the offense and then sentenced. So that's the first 2. I think the third most common, at least the one that applies to criminal law, applies to juvenile law. And that's called a deferred disposition, right? Isn't this is something now we've got deferred sentence, deferred prosecution, and deferred disposition. Deferred disposition is a statute as well. We're going to link to it in the description. But it basically says in most juvenile cases, if the juvenile is charged with a crime, someone who's under 18, and it's not a sex offense, and they don't have a prior felony, and they don't have several prior deferred dispositions, the court can, upon acceptance of a guilty plea to a charge, defer the disposition for the juvenile. And that means the juvenile's going to have probation. They might have some court costs. Typical probation would be at least a year. But if the juvenile completes the terms of the probation, including restitution and other affirmative conditions, then the court will undo that guilty finding and dismiss it. And it's a little bit better than a deferred sentence. That doesn't necessarily apply in the same way on the juvenile side. A deferred disposition has a much bigger effect of cleaning up a guilty plea on a juvenile case. And so they're very useful tools on some major type of offenses are not available, or if there's prior felony convictions are not available. But you definitely want to talk to your attorney if you're a juvenile and you're looking at having to plead guilty to something to see would you be eligible for a deferred disposition and should you use it. There's good reasons to use it and some reasons not to, and it varies case by case. But a deferred disposition applies to juvenile matters. And then finally, I think the one that I hear about also is what's called a deferred finding. So that's number 4, a deferred finding. Deferred findings apply to traffic infractions. So there's a law, and we're going to link to it again in the description, that says once every 7 years you can ask a court to, instead of convicting you of a moving violation, speeding or following too close or things like that, you can ask the court to defer the finding against you. And what that means is the court's not going to send a conviction notice to Department of Licensing. They're going to hang on to the case. The court is going to typically charge you a court cost. In many local courts, it might be around $100. And then most courts are going to say, hey, we're going to dismiss your infraction. We're just going to hold it. We're going to defer it. We're going to dismiss it if you have no more infractions for 12 months. Okay, there is some courts say the period of deferral is from the time you enter the deferral until you go pay whatever the cost is, and those are great courts to have a ticket in. But for the most part, the courts will say you need to stay out of trouble for a year. And you can only do that once every 7 years for a moving violation and once every 7 years for a non-moving violation. I don't know why you would ever do it for a non-moving violation because, you know, it's not that big a deal. And there's some exceptions. If you're a commercial driver, you're not eligible for a deferred finding if you have a commercial driver's license, or if you happen to have been driving a commercial vehicle, you're not eligible. There's also a certain type of negligent driving with a vulnerable user or vulnerable person involved in it. That's also excluded. So would you want to use a deferred finding? Well, you might. It depends on if you have a pretty bad traffic record and the court is willing to consider it. Probably a pretty good idea to use it because you may not be able to negotiate your way out of it otherwise. So those are 4 different types of term deferred. So if you have a case, and you hear your lawyer talking about deferred or your friend talking about deferred, the prosecutor or the judge, well, hopefully this video was helpful in letting you know what they might be talking about. Again, we have videos on the Deferred Prosecution, and you can look at that as one of the most serious programs you can engage in to try to get out of a problem. So again, if you found this useful, please like and please subscribe. More people will get the help they need. And even more importantly, if you have a situation where you need a criminal lawyer and you need some advice, feel free to give my office a call. Again, my law firm's been doing this for more than 20 years, all throughout Washington State. We'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.